Hello again, you're watching The Full View. Thank you very much for staying with us. Now, South Africans can expect some light at the end of the tunnel. Well, that's according to the Minister of Public Enterprises, Pravin, Gordhan and Eskom executives. They say the lights will stay on during the coming winter months, following nearly 2 weeks of stage 4 load shedding last month. Gordhan and the power utility briefed the media on how they plan to keep the lights on. But of course, in addition to that, a number of small businesses are looking at a class action suit against Eskom in relation to some of the damages as a result of load shedding. Now, joining us to chat a bit about this is a constitutional law expert, Advocate Michael Osborne. Advocate, thank you very much for your time this evening. I think when I heard about this, I really wanted to know if you've already quantified this exactly. How many small businesses are we talking about here?
Well, let me clarify first of all that I'm not involved in the suit. I'm aware of what is planned.
Yes.
I don't know whether there's been any quantification. I suspect not, because what is being claimed will depend upon the number of claimants and the nature of their businesses. You take, for example, a restaurant that's had to close or cancel reservations because of load shedding. Yeah. In principle, a restaurant can quantify what profit it would have made for that particular evening, and that would be its claim. Mm. Now, you take 100 or 1,000 restaurants and factories and offices. Each of them would have to put in a claim quantifying the profit that they have lost, and that would provide a multiple and the aggregate claim in the class action.
All right, Advocate, is this merely about recovering what these businesses have lost in this particular instance? And, what are we looking at? What could we possibly be looking at here in terms of, if this does go ahead, how much these companies could be looking for?
Well, each company can define its own loss, but if you look at potentially thousands or tens of thousands of members of the class that come together to bring a class action, it could be millions, tens of millions, hundreds of millions of rands that would be sought.
Yeah, but this is not an easy task. There are obviously some legal obstacles, which include the doctrine of state immunity, where one cannot sue the state. Can you explain that to us, and what legal route then would be available for these applicants? Well,
under the common law, the state is immune from suit because of the possibility that the state's omission or commission could cause such a magnitude of damages that it would be impossible for the taxpayer to bear the burden. Mm. This is different, though, because in principle, Eskom is a state-owned enterprise, but it's a separate corporate entity. It's not an organ of state per se. Let me rephrase that. It is not, by definition, an organ of state. Mm-hmm. One would then argue that the doctrine of state immunity does not protect Eskom in this particular case.
Mm. What are the chances of success if you say there is cause for these applicants to proceed on the fact that Eskom does have that responsibility to ensure that the lights are kept on?
Well, one thinks of what the major obstacle might be. If you look at a bulk electricity supply agreement, typically what you'll have there is a stipulation in the contract that Eskom will not be liable for consequential damages arising out of a power outage. And one can imagine why Eskom would insist on such a provision, because the consequences of liability would be utterly enormous. There's a way around that, though. One could argue that although such a clause protects Eskom from damages owing to negligence, one could say that it could never have been envisaged in the contract that an entity like Eskom could be immunized against gross negligence or even some sort of positive malfeasance or corruption. One could say that this is a case where the immunity built into the electricity supply contract does not protect Eskom from such a lawsuit.
I'd just like to get your view, Advocate Osborne. Do you find it strange somewhat? I mean, we heard from that press briefing that was given by the Public Enterprises Minister Pravin Gordhan and some Eskom executives today, saying that we should not anticipate load shedding, or at least they will try to keep the lights on. There might be no interruptions, in the near future, stretching to August. Do you find it strange that all of a sudden we're at stage 4 load shedding, and then all of a sudden now Eskom says we're able to keep the lights on even during the winter?
Well, I can't speak to that. I'm not an expert in electricity supply. So I don't know what the circumstances are that would have led to that. But just to clarify, irrespective of whether there is any further load shedding, these claims would be retrospective in the sense that they would arise out of the load shedding that has already occurred in the past.
Yes. But this could take years, Advocate Osborne. I mean, we've seen quite a number of class actions, of course not of this particular nature, but they usually drag on for years before you get any kind of recourse, if at all you do get any.
That's right. These things can take forever. One has seen the asbestosis suits, for example, the miners who were afflicted with asbestos poisoning. Then you've seen the cases against Premier Food and the price-fixing class actions. These things can take forever. However, ordinarily, if the defendant can see that some sort of liability is likely to be imposed, they'll settle. And the settlement can, in fact, come fairly quickly. It need not take years.
But what are the prospects of success in this particular matter? And don't you think it would open a can of worms, basically? Because, I mean, you've got quite a number of businesses. We've seen the effect that this load shedding has had on businesses and, the cost to them as a result of the lights being off. This could open surely a can of worms, and you might find hundreds of, or if not thousands of businesses that might even join this.
Yes, indeed. That is the problem. And in fact, there's something called the floodgates doctrine, where courts will be reluctant to award the kinds of damages, especially those that will ultimately be picked up by the taxpayer.
So what are the prospects of success, though, then, Advocate Osborne?
Well, it's very difficult to say that because this is very novel. It's entirely novel in South Africa. We've seen in the United States, where in California and New York, you've had what they call brownouts there, and private electricity utilities have indeed been found liable and have had to pay damages. So there's a precedent one can look to. The big difference, though, is that these utilities there are indeed privately held. There's no possibility of the taxpayer having to pick up the tab. And one can imagine a court being less eager to order damages against what's essentially a state-owned corporation.
No, absolutely. It could open up the floodgates for many other companies, the small businesses that have long been complaining about the effects that load shedding is having on these particular companies. That was constitutional law expert Advocate Michael Osborne talking to us about some small businesses that are looking to bring a class action against Eskom over recent load shedding, if we look at the costs and the effects it's had on loss of business. Francis?